Thank you, Mr. Chairman. Mr. Director, in 2012, John Spencer, Chief of Firearms Technology Branch, wrote a letter to Alex Bosco, inventor of stabilizing brace. We've talked about this letter already. He said, based on our evaluation, FTB finds that the submitted firearm brace, when attached to a firearm, does not convert that weapon to be fired from the shoulder and would not alter the classification of a pistol or other firearm. You're aware of this letter?
I am aware of the letter, yes.
Did Congress pass, between this letter being issued to Mr. Bosco and the production and distribution of 10 to 40 million of these braces and the implementation of your rule, did Congress pass a law? What changed?
Congress did not pass a law, but something did change. What changed is that that item that was submitted was not produced and was not the item that was marketed. And Mr. Bosco, I think, before this committee said that people were using stabilizing braces in ways that he hadn't anticipated.
Okay, let me challenge that assertion. So you say that the brace changed, and so you had to implement this rule. Well, I've got here the actual original brace that this letter was responsive to. Are you telling me that this brace is exempt from your rule?
What I'm saying is that if people have products that are not
designed... Is this brace exempt from your rule?
I can't sit here and classify.
This is the brace you wrote the letter to.
We will give it a classification, and if it's not ruled to be attached as a short-barreled rifle, it will not be subject to the rule.
Would you please quit telling this committee that the brace has changed and that's why you did the rule, when in fact you're not exempting the same brace that you gave this letter to?
If the brace is submitted, we'll classify it.
Would you submit, do you still have the same agreement that this brace that the ATF agreed to in 2012 should not be under the jurisdiction of your rule?
If that brace is submitted with a firearm, we will examine and classify it. If it doesn't qualify...
Okay, reclaiming my time, because it's pretty obvious you're misleading people here when you say that the brace has changed, because your rule affects the braces that didn't change. How many days have passed? How many days do people have to comply with this rule?
They can always comply, but the initial period...
Before they're felons?
But the initial period, I believe... ends at the end of May.
Okay.
But people
end of May. So and it was 120 days. Is that correct?
People are only felons if they intentionally
Is it 120
violate
days?
The law. I believe it's 120 days from the
So we've got 36 days left of the 120-day grace period. Can you tell us here today how many people have complied by registering this product?
I am not sure of the exact number. I can check, though, and get back to you. There are people who are making applications. There also can be detachment. So in other words, we don't count, that's not for us to regulate. If somebody we wrote the rule to make it easy to comply with. If somebody just at their home detaches the weapon from the brace and keeps them apart, they do not have to register anything. They can keep the brace, they can keep the business end of the gun.
Okay, that's a great clarification. So you're not going to do some kind of constructive prosecution where you say, oh, well, you had this and you had that and you intended to connect them?
They
can just keep them separately?
Them as we
keep them separately. Okay, because that's not clear in your rules. What is the punishment if somebody is convicted as a felon under having this piece of plastic?
If people are convicted of not following the Gun Control Act, it's a serious felony conviction, but that requires intent.
Can you just give me the number? Is it 10 years?
I believe it's a statutory maximum of 10 years.
10 years for owning a piece of plastic that you were told was legal and that you owned for a decade and that millions of people did? This is what offends the sensibilities of Americans, whether they own these or not. Do these make the gun fire more rapidly?
The stabilizing.
Do these increase the muzzle velocity?
The stabilizing.
Do these allow you're not answering any of the questions. Do these allow the firearm to carry more bullets?
The stabilizing braces allow, if they're the kind that count, allow the firearm to be shouldered.
Let me ask you
this. That Congress
I'm glad you brought that up. So this is a stabilizing brace here. Here's a pistol without a stabilizing brace. Does the buffer tube, could that be shouldered?
Again, that would have to be submitted to the firearms experts at ATF, and we could classify it.
Do you think you have the authority to reclassify this pistol as a short-barreled rifle simply because it has a buffer tube?
Again, the rule is aimed at clarifying, and there are specific factors that are set forth in the rule.
Do you think you have the authority to reclassify the firearm above because it can be shouldered?
Again, for me to sit here and try to do a classification that firearms experts who've worked for decades do would not be appropriate. But we will give classifications, and if things don't qualify under the rule, then they don't qualify. And nobody, the piece of plastic in and of itself is absolutely not covered by the rule.
I submit you don't have that authority, and you don't have the authority to do what you did. I yield back.
The gentleman yields. Next, I'd like to recognize the gentleman from Rhode Island, Mr. Cicilline.
Thank you. From Kentucky is recognized for 5 minutes.
I thank the chairman. Director Wray, in light of information provided to us about the FBI's investigation of the January 6th pipe bombs, in an interview with Assistant Director Stephen D'Antuono, Chairman Jordan and I sent you a letter a month ago. Some of the information that we found in that interview was that phone data that could have helped to identify the pipe bomber was corrupted, was unusable. He also wasn't sure who found or how the second bomb was found at the DNC. Do you know how the second bomb was found at the DNC? And when do you plan on answering our letter?
Well, as to the letter, I will work with the department to make sure we can figure out what information we can provide. As you know, this is a very active, ongoing investigation, and there are some restrictions on that, but we will do our best to respond.
Yes, we can handle classified information, and we fund your department, and so you need to provide that.
It's not, respectfully, it's not an issue of classification. It's an issue of commenting on ongoing criminal investigations, which is something that by longstanding department policy we are restricted in doing. And in fact, the last administration actually strengthened those policies partly because—
That's not our policy, though, and we fund you, so let's move on. Do you know how the second pipe bomb— can you tell us how the second pipe bomb was found at the DNC?
Again, I'm not going to get into that here.
900 days ago is when this happened, and you said you had total confidence we'd apprehend the subject. We've found video that looks like somebody, a passerby, miraculously found this pipe bomb at the DNC and then notified the police. Miraculously, I say, because it was at specifically the precise time to cause the maximum distraction from the events going on at the Capitol. Can you show this video that we have, please? I'd like to know if the director has seen this. This is somebody with a mask on, wearing a hat. They're walking in front of the DNC, which is out of the view on the right-hand side. You'll see him come into view. He goes to one police car. He goes to another police car. He's holding a backpack. He's got a mask on. He's talking to the police. And within a minute, they start scrambling. You'll see the camera turn to the pipe bomb, the location of the pipe bomb. By the way, that's, I believe, the Metro police are now getting out of their car, and that's Vice President-elect's detail in the black SUV, I believe, parked about 30 feet from the pipe bomb, eating lunch. Okay, now we go over to the location of the pipe bomb. The cameras are scrambling. It appears to me that that's not a coincidence, that the person with the backpack who walked by that bench and then went up to the police and the detail didn't do that accidentally. They had a purpose in mind, and that what transpired after that was the result of information that person gave to them. If that person found the pipe bomb, would they be a suspect?
Well, again, I don't want to speculate about specific individuals. I will tell you that we have done thousands of interviews, reviewed something like 40,000 video files, of which this is one, assessed 500-something tips.
Have you interviewed that person?
Devices. We have conducted all logical investigative steps and interviewed all logical individuals at this point.
Then it's 900 days. You need to tell us what you found, because we're finding stuff you haven't released into the public. In my remaining minute, I want to turn to another issue. George Hill, former FBI supervisory intelligence analyst in the Boston field office, told us that the Bank of America, with no legal process, gave to the FBI gun purchase records with no geographical boundaries for anybody that was a Bank of America customer. Is that true?
Well, what I do know is that the a number of business community partners all the time, including financial institutions, share information with us about possible criminal activity, and my understanding is that that's fully lawful. In the
Did you ask for that information?
In the specific instance that you're asking about, my understanding is that that information was shared with field offices for information only, but then recalled to avoid even the appearance of any kind of overreach. But my understanding is that that's a fully lawful process.
Was there a warrant involved?
Again, my understanding is that the institution in question shared information with us, as happens all the time.
Did you request the information?
I can't speak to the specifics.
Okay, well, we've got an email where it says the FBI did give the search queries to Bank of America, and Bank of America responded to the FBI and gave over this information without a search warrant. Do you believe there's any limitation on your ability to obtain gun purchase data or purchase information for people who aren't suspects from banks without a warrant?
Well, now you're asking a legal question, which I would prefer to defer to the lawyers, since I'm not practicing as one right now, including the department. But what I will tell you is that my understanding is that the process by which we receive information from business community partners across a wide variety of industries, including financial institutions, sharing information with us about possible criminal activity is something that is fully lawful under current federal law.
It may be lawful, but it's not constitutional. I yield back.
The gentleman yields back. The gentleman from Kentucky is recognized.
I thank the chairman. You know, my constituents aren't contacting me worried about mergers between tech companies or that sort of thing, but one of the things I've been contacted about multiple times is the small independent grocers feel like their monopolistic practices being used against them. And Mr. Correa and I sent a bipartisan letter to you asking for an update because in November 29th, 2021, this is 17 months ago, FTC ordered 9 large retailers, wholesalers, and consumer goods suppliers to provide detailed information to help you study the causes behind ongoing supply chain disruptions. And I appreciate you being willing to give us a briefing, but can you brief us today? Like, what have you found? And are you going to be able to help these folks who are complaining about they can't get products or there's discriminatory pricing, not based on quantity, but based on other things or different package sizes? What can you tell us here today?
Yeah, this is such an important issue, and we've heard from those independent folks as well, and it's partly what informed our decision to launch this study. We're moving as expeditiously as we can. As you can imagine, sometimes firms don't have an incentive to give us all the information we need as quickly as we need it, but we are moving ahead full speed and happy to be providing you with the non-public briefing to share what we've found so far, and we'll be looking to make our findings public as soon as we can.
I hope that's soon. There's been 17 months since you asked them to give the information. I understand it takes them a while to get it to you, but I would hope we would get that very soon. Another issue that concerns many of us are these so-called pre-consummation warning letters. On August 3rd, 2021, FTC announced that it would send warning letters in connection with transactions it cannot fully investigate within the time provided by the statute before the deal closes. Well, now, why should people trying to do regular business be punished because it's taking you too long to do your job? And how many of these so-called pre-consummation warning letters have been sent by the FTC?
So the statute gives us only 30 days to look at a deal to determine whether we need to investigate it further. As deals have become more complex, that can be a very, very, very tight timeline. We've heard from some businesses that if we don't act within that 30-day period, the takeaway for them is that there are no issues and there are no concerns. So we thought it was important to put business on notice, to provide them clarity and transparency, that if there is a deal that we think raised concerns, but we weren't able to act within the 30 days, that we're putting them on notice about that, again, to make sure that the market has clarity on it.
Commissioner Phillips publicly suggested that within the first 6 months of this practice, over 50 letters were sent, and raised the question of whether any of those investigations actually remained open and whether this approach was simply a tactic to scare business. I'm worried that whether it's a tactic or not, that's the effect that it's having. It's having a chilling effect. And then when you issue one of these letters and then you never tell them whether the case is closed or not, kind of without doing anything, you've stopped transactions that would be helpful to Americans. Let me, I want to now yield back the remainder of my time to Chairman
I
Jordan.
appreciate the gentleman yielding. When the FTC attorney deposing Mr. Roque asked him to confirm that, quote, no one from the FTC directed you to reach a particular conclusion about Twitter's program, he explained to the contrary. There were suggestions of what they would expect the outcome to be. He testified that the FTC communicated to Ernst & Young. Again, Ernst & Young is the independent assessor, the fact finder that the FTC selected and made Twitter pay for, that he communicated to Ernst & Young that, quote, Ernst & Young, under all circumstances, will be conducting and issuing a report on behalf of the FTC order, and was very adamant about this is absolutely what you will do, and this is going to occur, and you will produce a report at the end of the day. The FTC was so adamant. Ernst & Young leaders feared that the FTC would take exception if they chose to withdraw from the case. So on the one hand, you're harassing Twitter, and then you're saying the guy we've selected, the entity we've selected, Ernst & Young, the accountant we've selected to be the fact finder, you better find what we want, and if you try to get out of it, we're going to retaliate against you. That is frightening. I mean, we talk about the weaponization of government, this from the same agency that said, tell us all the journalists you're talking to. That's what we're concerned about, Ms. Khan. That's what has to change. You can comment if you want, but I'm reading from the motion filed today in court. And it's amazing to me, you don't even know this guy. You don't even know who this person is, and your lawyers deposed him. He's the guy that you set up as the fact finder, and you didn't know who he was. Did you sign off on any of those 12 letters sent to Twitter in that 10-week time frame?
Congressman, we're fortunate to have a lot of work underway. A lot of this work is delegated to the frontline staff that are able to move quickly and nimbly to make sure.
Yeah, but you're in front of Congress today. You knew you were going to get questions about this. Yeah, you don't know this. I find amazing.
It sounds like it was a late-breaking development in a filing this morning. It's not something that's on my radar. I'd be reluctant to weigh in on it in this setting without looking more closely at it. Happy to take questions for the record on it and engage later.
Not on your radar that you told, based on the testimony of this guy, that he felt there would be retaliation if Ernst & Young tried to get out of the agreement. Wow.
I yield back.
Wow. Gentleman yields back. Now recognized. The gentleman from Kentucky is recognized.
I thank the chairman. Secretary Mayorkas, the Department of Homeland Security issued a National Terrorism Advisory System bulletin this year in February. It said the United States remains in a heightened threat environment fueled by several factors, including online environment filled with false or misleading narratives and conspiracy theories, and other forms of mis, dis, and malinformation. Can you define malinformation for us?
Congressman, we're dealing with false information that is used for a particular purpose.
Isn't malinformation actually true information that may be inconvenient to the establishment orthodoxy?
I'm sorry, Congressman.
Isn't malinformation a made-up word that refers to information that's actually true but just inconvenient to the government narrative?
That is not true, Congressman.
Let me ask you this. You said that the proliferation of false or misleading narratives sow discord and undermine public trust in U.S. government institutions. Is it illegal to undermine public trust in U.S. government institutions?
Congressman, we become involved because we believe in the First Amendment right, and we have safeguards to protect it. We actually have a statutorily created Office for Civil Rights and Civil Liberties. We become involved not with respect to a particular ideology. We are ideology neutral, but it's the connectivity to violence.
Isn't larger government an ideology, the bigger government? Let me ask you my original question. Is it illegal to undermine public trust in U.S. government institutions?
Congressman, we understand First Amendment principles. We embrace and protect them. Individuals can espouse whatever ideology they believe in.
And so let me ask you the question, if you just answer it directly. Is it illegal to undermine public trust in U.S. government institutions? Isn't that, in fact, what we're doing here today? When we point out that you've released 1 million or 2 million people into this country without trying to deport them? I mean, are we, in fact, undermining trust in your institution? Aren't we doing that? And isn't that actually healthy when we point that out?
Congressman, may I share with you what the Department of Homeland Security does with respect to ideologies?
I need to
What we
ask you
do-
another question since you haven't answered any of these yet. You say that there is widespread online proliferation of false or misleading narratives regarding COVID-19. Is the claim that natural immunity is real, is that a false or misleading online narrative?
Congressman, we do not evaluate particular ideologies or particular narratives. Our focus
How about
is
the
on-
claim that vaccines don't stop the spread of the virus? Was that a false or misleading COVID narrative?
Congressman, what we do is we are involved when there's a connectivity between an ideology, whatever that ideology.
How about, I'm not talking about ideology, I'm talking about COVID-19. Is the notion that masks were ineffective at stopping transmission, was that a false or misleading narrative?
Congressman, allow me to repeat. What we get engaged in is a connectivity to violence. It is our responsibility to prevent violence from occurring. We work very closely.
Is it, all right, I'm just saying, I want you to give me an example of a false or misleading narrative that encouraged violence. That you say that that grievances associated with these themes inspired violent extremist attacks during 2021. Extremist attacks? What are you talking about in this document when you say that false or misleading narratives about COVID-19 inspired violent extremist attacks during 2021? Can you give us a single example? I've given you some questions. Was it the narrative that this may have leaked from a lab in China? Was that the thing? And if so, what did it inspire? What's the violence?
Congressman, would you like an example?
Yeah.
Yeah. COVID-19 is caused by 5G cell towers, an attack on a cell tower. That attack on a cell tower triggers the involvement of the Department of Homeland Security. That is an example. It is the connectivity to violence. We do not condone
You
violence.
think COVID-19 caused attacks on cell towers? I think you're
Congressman, that is
chasing ridiculous things.
Mr.
People
Chairman,
watching this at home,
Mr.
they
Chairman,
got to be just amazed that you would
Chairman,
espouse
can the
this.
witness be allowed to answer? Can the
No,
witness be
he is not. He said that false or misleading narratives about COVID-19 need to be censored. He's implying that they need to be censored because getting out this information, the free speech, is somehow dangerous to our country.
Chairman, he didn't say
In the
that.
context of COVID-19, I completely disagree. He didn't give us an example.
Chairman, can he
And I
answer?
yield back the
Can the
balance of my
witness-
Can he
time.
answer the
Witness
question
answer the
because he's
question.
being misquoted?
The time belongs to the gentleman. He has yielded back. The time now goes to...
I'm going to direct your attention to a video here that we're going to play.
Obviously, that's a significant matter. It is an ongoing criminal investigation, and so I'm not going to comment on an ongoing criminal investigation.
Were those pipe bombs operable?
Again,
The ATF is the expert.
Again, it's an ongoing criminal investigation, and under longstanding policy, I cannot comment.
As you know, this is a very active, ongoing investigation, and there are some restrictions on that, but we will
Yes,
do
we
our
can
best to
handle
respond.
classified information, and we fund your department, and so you need to provide that.
It's not, respectfully, it's not an issue of classification. It's an issue of commenting on ongoing criminal investigations, which is something that by longstanding department policy, we are restricted in doing. And in fact, the last administration actually strengthened those policies partly
That's
because—
not our policy, though, and we fund you, so let's move on. Do you know how?
Did. So I'm not going to violate this norm of the rule of law. I'm not going to comment on an investigation that's ongoing.
Peter Navarro was indicted for contempt of Congress. Aren't you, in fact, in contempt of Congress when you give us this answer? This is an answer that's appropriate at a press conference. It's not an answer that's appropriate when we are asking questions. We are the committee that is responsible for your creation, for your existence of your department. You cannot continue to give us these answers. Aren't you, in fact, in contempt of Congress when you refuse to answer?
Congressman, I have the greatest respect for Congress. I also have the greatest respect for the Constitution and laws of the United States. The protection of pending investigations and ongoing investigations, as I briefly discussed in another dialogue a few moments ago, goes back to the separation of powers, which gives to the executive branch the sole authority to conduct prosecutions. It's a requirement of due process and respect for those who are under investigation, the protection of their civil rights.
Well, with all due respect to that, Iran-Contra was an ongoing investigation, and that didn't stop Congress from getting the answers. And you're getting in the way of our constitutional duty. You're citing the Constitution. I'm going to cite it. It's our constitutional duty to do oversight. Now, in that video, that was your answer to a question to me 2 years ago, when I said how many agents or assets of the government were present on January 5th and January 6th and agitating in the crowd to go into the Capitol, and how many went into the Capitol. Can you answer that now?
I don't know the answer to that question.
Oh, last time, you don't know how many there were, or there were none?
I don't know the answer to either of those questions. If there were any, I don't know how many. I don't know whether there are any.
I think you may have just perjured yourself that you don't know that there were any. You want to say that again, that you don't know that there were any?
I have no personal knowledge of this matter. I think what I said the last time.
You've had 2 years to find out. And the day, by the way, that was in reference to Ray Epps, and yesterday you indicted him. Isn't that a wonderful coincidence? On a misdemeanor. Meanwhile, you're sending grandmas to prison. You're putting people away for 20 years for merely filming. Some people weren't even there yet. You got the guy on video who's saying go into the Capitol. He's directing people to the Capitol before the speech ends. He's at the site of the first breach. You've got all the goods on him, 10 videos, and it's an indictment for a misdemeanor? The American public isn't buying it. I yield the balance of my time to Chairman Jordan.
May I answer the question?
I'm going to ask you one now. We'll let the gentleman.
Yeah.
Go ahead, but
In discovery, in the cases that were filed with respect to January 6, the Justice Department prosecutors provided whatever information they had about the question that you're asking. With respect to Mr. Epps, the FBI has said that he was not an employee or informant of the FBI. Mr. Epps has been charged, and there's a proceeding, I believe, going on today on that subject.
the charge is a joke. I yield to the chairman.
The time the gentleman has expired. The chair recognizes the gentleman from California.
Mr. Attorney.
Recognize the gentleman from Kentucky.
Attorney General Garland, Elon Musk was a Democrat who admittedly supported Biden, but then he became a critic of the administration and exposed the censorship regime. Now, per public reports, the DOJ has opened not one but 2 investigations of Elon Musk. Mark Zuckerberg, on the other hand, spent $400 million in 2020 tilting the elections secretly for Democrats. No investigations whatsoever. To the American public, these look like mafia tactics. You pays your money, we look the other way. You get in our way, we punish you. The American public sees what these tactics are. Now, I want to direct your attention to a video here that we're going to play.
Obviously, that's a significant matter. It is an ongoing criminal investigation, and so I'm not going to comment on an ongoing criminal investigation.
Were those pipe bombs operable?
Thank you, Chairman. Mr. Massie.
Thank you, Mr. Chairman. Secretary Buttigieg, in addition to sitting on this committee, I serve as chair of the subcommittee in the Judiciary on the Administrative State, Regulatory Reform, and Antitrust. You said on CNN, I believe, that, quote, the Department of Transportation has generally not gotten involved in these merger cases, but that's changing today. Was that statement in reference to the JetBlue Spirit merger?
Yes, partly.
It troubles me somewhat as you know, being on the subcommittee on antitrust in the Judiciary, because the DOJ is already reviewing airline mergers to see if the mergers are anti-competitive. And it seems like a waste of resources for 2 agencies to duplicate work, but I'm worried that's exactly what's happening if DOT and DOJ are going to review the same merger. So do you think that the DOJ and FTC, for that matter, are unable to review mergers and protect American consumers?
Oh, of course not. The way the division of labor works is that we have distinct but sometimes overlapping authorities. And so, as is often the case when you have different parts of the interagency dealing with the same issue, we seek, to the extent that it's statutorily appropriate, to coordinate. I'm going to be limited in how I talk about this because, of course, this is an open proceeding. But what we're trying to do is stand with DOJ, align our authorities where they cover the same turf, but also recognize that with regard to our, in my view, too long unused authorities around public interest, that we're also ready to activate those, especially because depending how the DOJ side goes to disposition, it might compel us to take other steps. Again, I don't want to get into the case too much, but depending on what's appropriate.
Do you agree that they're the only ones who should be evaluating whether this is anti-competitive or not?
Do I agree that the DOJ...
I mean, you said that you both have some authority here, but that you didn't want to duplicate it. And their main authority and responsibility is to decide if this merger is anti-competitive. You're not seeking to relitigate that, are you, after their decision?
Well, again, we're trying to work with DOJ to the extent that's appropriate. And then we have our own responsibilities that are separate.
So, you know, they have a standard for anti-competitiveness. What is your standard of, or principles, the limiting principles of whether this is in the public interest?
Well, again, let me take care to caveat that I'm not commenting on the open proceeding, but I'm
right, I'm
about how we
talking
approach
generally.
So it really follows from what the law calls for. And again, there's really two sides of this. So there is DOT's responsibilities and authorities with regard to competition policy that are laid out specifically in the law, even though they haven't been used very much. And then there's also, in addition to the Clayton side, there's the public interest responsibility that we have that is somewhat distinct and will have to follow a distinct rubric from what is applied in the jurisprudence you've had around competition on the DOJ side up till now.
Can you give me some examples of things that might run afoul of public interest that aren't in the domain of DOJ's responsibility to determine whether it's anti-competitive or consumer welfare benefit?
I think if I tried to get into hypotheticals, it would be at risk of being perceived as prejudicing this case. But what I'll say is that the law is written differently with regard to our competition authorities, creating an overlapping, not identical, but also not simply parallel authority.
The reason we have questions here is it's been about 3 decades since somebody said a statement like yours that leads us to believe you might be relitigating or some of the things DOJ is doing. So I'm looking for the limiting principles.
Yeah, so again, I don't want to make case law on the fly here, but we have a responsibility to review the public interest associated with these competitive dynamics that was entrusted to our department, basically as a condition of deregulation. At the time of deregulation, it was confidently pronounced that we would go into the future with dozens, if not more than 100, competitive major airlines. As you know, we're depending how you count, down to 4 or 5. So we know that there is something in the way that this has been practiced over the decades that is, at the very least, out of alignment with what was expected as an outcome of regulation. And that's why we think, following the law as written,
I got
we have a
3 seconds
responsibility to
left.
get more involved.
I appreciate that answer. I got a real quick question. Tesla spent billions of dollars on a charging infrastructure, and now the government says they're going to do the same thing. What's it going to cost the government to do this? And doesn't it disincentivize private investment when the government comes along and says, we're going to create these chargers? What incentive does Tesla have to do it anymore? And when will there be enough charging stations available nationally that no family will again be prohibited access from one of these chargers due to a cabinet member's promotional tour?
What's great about Tesla's decision is that they're opening their chargers to not be a walled garden, but to be available to other vehicles too. We welcome that. But even that built infrastructure alone of Tesla's, which is remarkable, is not on its own enough to meet the national charging demands of the country. The simple answer to your question of how much is that we have $7.5 billion going against this goal as provided by IIJA. But the other thing I would point to is that there will be gaps in areas that it might not be profitable yet for a company to install a charger. And I would point here to rural areas or low-income areas, as an example, where we want to make sure we accelerate that process. And so that's why we think it's appropriate and important to introduce those federal dollars to speed up that process alongside the private sector dollars. And it's going to be a race. I mean, getting to that 500,000 chargers that the president envisions by the end of this decade will require both with those installed with and those installed without federal subsidies to move at a really fast clip.
My time's expired. I don't think there should be a race between government and private enterprise.
Oh, it's not a race between us. We're racing in the same direction.
And I yield back.
Chair recognizes the gentleman from Kentucky for 5 minutes.
Thank the chairman. Ms. Troy, you stated in your opening statement that this committee was indulging in fantasy detached from reality, that members of this committee and their witnesses make grand and vague accusations about government censorship, and that we are spreading conspiracy theories about government censorship. Would one of those conspiracy theories be that government-funded agencies were flagging and trying to censor official congressional accounts on social media? Are you denying that that occurred?
I would have no knowledge of that. I'm not aware of that happening.
Well, we're going to make you aware of that right now. Mr. Schellenberger, can you speak to this tweet? I saw that you flagged this in one of your recent articles on Substack. Can you tell us why this tweet brought attention in your article?
Yeah, because that was one of the tweets that that the Virality Project at Stanford Institute Internet Observatory had flagged to Twitter as misinformation, and that I believe it was labeled or censored in some other way.
So it was the Stanford Virality Project, that is funded by the government, is it not?
Yes, it is.
And so their purpose, ostensibly, is to stop misinformation, malinformation, and to flag things they say that might be against the terms of service of the social media companies. Is that correct?
Yeah, that's right.
Ms. Troy, is there any reason you think that this should have been flagged?
Depends on whether you're spreading inaccurate information.
Well, it references a study from Israel, a published study from Israel, and the tweet just restates the title of the study. Does it trouble you that
companies to review their policies? It's an internal choice.
Yeah, are you going to sit here and maintain that it's a conspiracy theory that this occurred? We have the documents. Mr. Schellenberger has the documents that showed that this occurred.
Well, then it was flagged for a reason.
What's the reason? Is there ever a good reason to censor a member of Congress? This is my official account. This is not a personal account. This is not a campaign account. This is my communication with my constituents. And by the way, I bring this up not to claim that members of Congress have more right to free speech than the general public. In fact, I don't even think the press or the media has more rights to the First Amendment than the general public. The general public has the same rights that we have. And I bring this up to show, number one, that your testimony is false. But number two, if they can do this to a member of Congress's official account, they can do it to anybody.